Hi, so good evening. Last week we discussed about the basics or the preliminaries of law of contract, and today in the business law lesson, our focus is to go through the business contracts in depth, which means that we just touched on the preliminaries in the business contracts, and there are some of the facts to be included, and there are some areas to be considered while you are drafting or while you are attaining to a business contract. So that is what we are going to discuss today. And here in the basics of the contracts, I'm going to discuss about the offer and acceptance today, as well as the lawful consideration of the business contracts. Right? There are two types of things to be accomplished by the parties, those who are attaining to a contract, which known as the one is the offer and acceptance, the other one is the lawful consideration. So today we are going to talk about these two, and of course, moving to an offer and acceptance principle. Uh, Let me show you an example. Now, let's say, as an now in a scenario where your one of your party, and you're now assume a situation where you and another party are going to come into a contract, right? So there, let's say it's an employment. It's an employment opportunity where you have applied for a job and they have been selected you and shortlisted you and they have been selected you for the position. Then after that, they'll inform you that you have been selected, and we will be, according to the discussions that we had, we will be giving you this much of package and this much of facilities pertaining to the role that you are going to act in your organization. So according to that, they will give you an offer. We call it as offer letter, right? Before your appointment letter, the letter of appointment, the employer will be given to you an offer letter. So what is the purpose of it? That is to convey the offer to you under that particular role or the designation of their company, right? We'll first get to know what the offer is. Offer, in general circumstances, in general scenarios, in day-to-day life, you may have made some sort of promises and you may have made some sort of offers to the others, and also you are making itself. In regular basis, you are making some offers, right? As an example, let's say while you are always, I mean, not in these curfew days, right? While you are driving, right, on your way home, you will meet one of your friends. So you will ask him or her to get onto your car, right? Just to drop, right? Just the purpose of having an intention of dropping him or her to his or her destination. So you will ask him or her to get onto your car. So that is one way of offering something, right? It's a regular way of offering, and that was, that offer was in oral way, right? You asked, right? So now in official way, let's say in a formal way, you cannot ask something, right? I told you, basically there's a principle called an offer or an acceptance has to be in written format, right? It should be in writing. So because of that, you should expect a letter of offer before you start your career with a company, right? So what do you mean by an offer? Offer can be easily defined as you can see, it's an expression by one person, or let's say one party, or group of people, group of personnel, or by agents on his or her behalf, made to another, right? They are offering to you, or let's say one person is offering to another, right? Of his or her willingness to be bound to a contract with that the other on terms certain or capable of being rendered certain, expression of willingness made to another party, and expressing with an intention of obtaining the assent of the other party. Now let's see, these are the characteristics, right? Basically I told you, capable of being rendered certain, right? In that sense, you see, there should be two parties. One party is making an expression to a party or group of people. Let's say party in the sense it can be a person or personnel, right? And the person who offers this offer or who expressed this offer is the offeror of this contract, offeror. And the party who receives this offer is the offeree, right? So once the offer is expressed by the offeror to the offeree, right, that is what you call as offer. Nobody has accepted it. Nobody has given their sort of willingness, not express the willingness on it, but still the offer is given by the offeror to the offeree, right? So here, see, there are three types. Now, when it comes to things, expression of willingness, rendered certain expression of willingness made to another party, expressing with an intention of obtaining the assent of the other party. See, the offer is made to get somebody's willingness on it. If somebody has agreed, then you can go for an agreement, or let's say a contract. Now, assume an example. Now, as an example, let's get the previous one. The letter of appointment. Before the letter of appointment, you've been given with the letter of offer. Once you receive the offer, it's up to you to accept it or not. If you expressed your willingness of accepting it, let's say by accepting, you are expressing the willingness to that particular offer. Being the offeree, that you received the offer from the company was the offeror, and you received it, so you are the offeree. Once after you received it, if you are giving the willingness to perform, which means that you have accepted it, right? Then they can make a sort of a contract of employment because you have accepted. Now, it's up to you to decide. You being the offeree, it's up to the offeree to decide whether you are giving the willingness or not. Simply, right? So expression of willingness made to another party by the offeror and expressing with an intention of obtaining the assent. So what is the purpose of giving this offer to the offeree? Offeror expects the willingness by the offeree to perform this act, to perform whatever they have mentioned in the offer, right? Like, let's say, as an example, you must work from 8 a.m. to 5 p.m. In the office premises. We'll say the place of work has to be mentioned in the letter of offer, and you will be paid this much of a sum. This is the normal or the regular way of making an offer, right? And your employee will be this company. Employer will be this company, and you are going to be a part-time or full-time employee, right? And also we will be paying you this much of EPF and ETF. That is the ratio, right? So all these terms are made. Let's say those are not terms, of course, that is the offer. And if the party, or let's say this offeree, has accepted by signing that particular document, the offeror can go for the further proceedings called drafting of the contract of employment. Right. Now, the characteristics are there in a valid offer. So what do you mean by a valid offer? Right? So there are so many characteristics. The first one is an offer must be expressed or implied. We've discussed about the express terms and implied terms in the contract, the law of contract, the basics and preliminaries. So the offer must be expressed to the offeree, or it has to be implied, which means that you are not directly expressing it. But of course, now as an example, let's say in letter of offer for the employment, it says that you are required to. It's saying, right? Now from the offeror to the offeree, it says offeree should work when and where the organizational management wants, as and when required. Right? As and when required, in the sense, it doesn't mean that you may need to work during the holidays, but of course it's implying, it's given, right? It's not expressly taught in your whatever the offer, but it says that you are required to work during whenever the circumstance that the management wants your assistance on their work, right? So that those are the ways that you call as implied terms, right? Expressed offer, or it can be an implied offer. Then the second one, must contemplate to give the rise to legal consequences and be capable of creating legal relations. Now, offer should be qualified enough to create a legal relation between the party that is given the offer as well as the party who receives the offer, which means between offeror and the offeree, it should be qualified enough to create a legal binding about, right? That is what you mean by must contemplate to give the rise to legal. Now, if somebody has make a dispute over it, so definitely you can go for the legal proceedings of whatever relevant for the disputes of these terms and conditions in the offer, right? Because one party has offered, in the sense the offeror has offered it and the offeree has accepted it, so which means that the offeree has agreed legally to perform that particular offer, right? So that is one. Okay. So don't be serious, huh? Right. So terms of the offer must be certain, not loose or weak, in the sense that let's say terms of the offer must be certain. Now, if you have entered some terms, I told you, you cannot, by being an offeree, let's say, in a circumstance, by being an offeree, you cannot accept the terms called, like at the end of that particular term, it's mentioning that etc. Such as, you don't, I mean, don't, never, I mean, never sign or never accept this much of offers. I mean, these types of offers, because it's not going to work, right? Such as, in the sense, there are implied such as examples, right? Now, as an example, let's say you are required to work the rural areas like Nuwara, let's say Kataragama, right? Rural areas, such as rural areas. So what are the other areas? So there's a question, right? Don't accept or don't make such sort of offers, right? It should be very specific on offer and not loose so vague. Should not give any sort of a space, or let's say the loopholes, to make through the offeror or the offeree. Don't ever make it, right? Third one is, an invitation to offer is not an offer. Now, as an example, we see in most of the newspapers there are so many vehicles advertised, or else in some of the newspapers I can see most of the condominiums, the apartment projects are advertised as not, those are like advertisements, right? Or let's say advertisement, in the sense it's just a sort of they are advertising there whatever the products available, right? It's not an offer, right? When it comes to invitation, of course, if you are invited for a particular thing, it's not the offer, right? Invitation cannot be considered as an offer, because invitation is just to have a look. That is not the offer. If you are absenting for an invitation, it doesn't mean like you have rejected the offer. No, offer is something else, right? I will definitely, after this YouTube video, you can do on your resource sites and things, you can see some of the case laws that I've attached to this particular video, where you can refer and see the persons, those who have made the advertisements, as well as the people, those who have made some of the invitations, been considered as offers, and they've sued over the persons, and there were so many legal consequences happened on these offers, right? Just because of now, don't make what do you call the confusions. Advertisements or else the invitations for the offer is not a valid offer, right? And an offer must be specific or general. I told you it should be very specific. An offer must be communicated to the offeree. Okay. Now, if you are expecting, now you be in the offeror, if you are expecting to give an offer to somebody, you cannot uh, just say, let's say, as an example, you cannot hide some of, oh, let's say, hide the part of it or in full to your offeree. And it should be expressed, or let's say, it should be communicated to your offeree. Without having much awareness, the offeree won't be able to agree to your whatever they offer, right? So offer must be communicated in a proper way. It can be either an email. In nowadays, we are mostly using some emails, right? And also, it should be a proper way of communicating, right? And for legal matters, of course, if you can make them in a legally provable way, let's say, if you are making an offer to a far distant personality, if you can make them through a registered post, or let's say if you can do through a mail, so that will be great. I mean, for your whatever the legal consequences, those will be very helpful for you to even to go for the courts as well, right? Let's say in a circumstance, right? Okay. An offer should not contain a term the non-compliance of which would amount to acceptance. Right? Offer should not contain a term the non-compliance of which would amount to acceptance. Okay? An offer can be made subject to any term or a condition. You can add any term or a condition, but of course make sure that you are including the terms and conditions which are legally can be challenged legally, right? Because if those are illegal, or let's say if they are not ethical, so you cannot, in a case of a dispute, you cannot lead them for a legal proceedings because those are not either legal or ethical, right? Then the crossover will not create a contract. Now, once now, as an example, if I'm the offerer, if somebody is the offeree, if I'm offering something to the offeree, if offeree is not actually he or she is making a counter offer, let's say, right, a cross offer to me, it doesn't make any contract on the offer that I gave to him or her, right? So you must be careful. Whenever you are making the offers, it has to be specific and needs to be communicated. It has to be, it should not contain any sort of counter, or let's say it should not contain any sort of crossovers, right? Okay. So we'll move further. Now, let's say as an example, some of the companies I have seen, some of the companies are making some offers, not only the employment, but also in some other cases as well. And they are making some mistakes on their offers. Assume a situation where you would have make a mistake for a post of clerk. Your legal assistant, or let's say your HR assistant, made a mistake on drafting the letter of offer and giving a monthly payment of 100,000. So probably they have edited some other letter of offer and given it to the that particular designation, right? So that is a basically typing mistake, right? But once the offeree has received it, he or she will willfully sign that particular document because it's a higher amount, right? Willingly they'll be signing, sorry, not willfully, willingly they'll be signing that particular document because they know it's a quite a huge amount for a clerk, right? But remember, we have a remedy for postpone, or let's say we have a remedy for a withdrawal of that particular offer. How can you withdraw? That is what you call as revocation, right? Or else you can, there's an offer which can be lapsed. Lapsed in the sense you are not going to perform this in a contract, right? Or let's say you are not going to perform this as an offer. Lapse of offer or a revocation. So we'll get to know about these two. Now, lapse in the sense it will automatically cease the right to becoming to an offeree or a offeror relationship. That will automatically cease. Now, after the stipulated or reasonable time of offer, let's say in an offer of employment, you will write a condition called this offer has to be accepted within 7 days. Within 7 days of this offer, right? So within 7 days in the sense that date that you have dated the letter. Let's say as an example, if it was 20th of March 2020, so it has to be signed on or before the 27th of March 2020. What happens if somebody signed it on 28th of March? Now there's a thing called postal rule. Now when it comes to your closing application, application closing times and things, you may have seen the closing dates are mentioned in the advertisements, right? So for the closing dates, that is considered the date that you have posted the letter, not the date that you have signed the letter, because you can backdate and sign it now. Because of that, mostly the institutions are considering the date which is sealed on your envelope. You can see it, right? Once you posted it under the registered post, the post office will place a stamp, the date stamp on the envelope. So that will be getting to the consideration when they are sorting the letters on the due date. So if your letter is not submitted on the due date, there's a point to say that the postal rule is not met, right? By considering it, you can also reject your particular document. When it comes to this stipulated time, or let's say the preferred time, or let's say the reasonable time, the offer will be invalidated or the offer will be lapsed. But don't be upset, because why? If you are not qualified enough to sign that particular document within the time stipulated, or let's say the time which is reasonably given to you, if you are the offeree, don't get upset, because why? They cannot accept that offer, or they can presume that you have accepted that offer. No, there's nothing, right? The offeror must receive the acceptance in a proper way from the offeree. Otherwise, they can't accept the offer. They can't make the contracts based on the offer. And not being accepted in the mode of prescribed. Now, as an example, if somebody asks you to, there are some of the conditions where whenever you are accepting especially the offers, right? Whenever you are accepting the offers, you must consider, now you being the offeree, let's assume you are the offeree. If the offeror is given to you a letter, and if they are asking you to submit that within this period, that is a stipulated time, in a mode of registered post, it's pointless even if you send it by scanning as an electric copy, or let's say e-copy, right? It's not the way that they're going to accept your letter, right? So that case is getting to the consideration in not being accepted in the mode of prescribed. It should be in the prescribed mode. And lapse by rejection. Now, lapse in the sense, if you are not in a position to accept that particular offer from the offeror, you being the offeree, you are having the right to reject the offer. By rejecting it after now let's say you have rejected, now you received the letter, let's say the offeror has given you 7 days, they have posted it on 20th of March and you received it by 23rd of March, and you are keeping the letter with you and not signing, not sending again back to the offeror, you are keeping them with you, and after 28th, since he didn't receive any sort of, offeror can assume that you may have rejected the offer. That's an assumption, right? Or else, if you can call, or if you can inform in any other way that you are not in a position to sign this agreement, or let's say you are not in a position to accept this offer, that is called lapse by rejection. Okay, you rejected it. You rejected the offer. So through that, the offer was lapsed. Death or insanity of the offeror or the offeree before the acceptance. Now, before the acceptance happens, if somebody dies, let's say offeror has passed away before he receives your acceptance on the offer, or else you, offeree dies before he receives the, or let's say before, even before the acceptance is given, or else before you receives the offer, or else the insanity. සිහිමද බව පිස්සු කියන එකට උන්මත්තක භාවය උමතු භාවය. In that case, if you met with a such sort of an insanity or deceased, the offeror or either the offeree cannot accept it as a valid offer in a case of death or insanity of the offeror or the offeree, right? Vice versa. Lapse by revocation. I told you, if you are not in a position to reject it, let's say in a case of mistakenly you have made a sort of a statement or a condition or a term in your offer, and you have already sent it to the offeree, you can ask the offeree to neglect, or you can ask the offeree to omit it by signing, because it's not a valid offer, right? Revocation of standing offer or tender. There are three ways, right? Of course, you can ask to withdraw that particular thing. That is what you call as revocation. Revocation of standing offer or tender, right? So there's one way of revocating. Non-fulfillment of a condition, right? You can ask, because of the non-fulfillment of a condition, you can revocate the offer. Third one is lapse by subsequent illegal or destruction of subject matter. Now, as an example, let's say we both are vendors, right? I'm the offeror, you are the offeree. So I'm actually a vendor who sells dal, right? I'm a wholesaler, right? And also I'm an exporter. So in case of dal, let's say rice, right? So I'm a rice exporter. So you are the offeree. So I will give my offer to you. And while we are, having discussions over this offer, the government regulates a regulation called omission, or let's say restricting the export of rice, right? Which becomes illegal. So because of that, the revocation can be happen, because the legality is not there, so the deal is illegal. So because of that, you can also omit that sort of an action. That is also one way of lapse by revocation, right? Hope you understood it. If you do have any concerns, you can send me an email. Acceptance of offer. Now the second one is acceptance. Even though you have offered, but if somebody hasn't accepted it, that won't be a valid offer and acceptance. You can't go for a valid contract. Okay. So acceptance of offer, in the sense an express act or implication by conduct that manifests assent to the terms of an offer in a manner invited or required by the offer, so that a binding contract is formed. I've taken this from the legal dictionary, the acceptance definition. So express act or implication by conduct can be considered as the acceptance of an offer, right? So there are so many types of acceptances. We can see conditional acceptance, express acceptance, and implied acceptance. Conditional in the sense, once you have received the offer, so you can ask the offeror to revise it. Conditional acceptance, right? We call it as the qualified acceptance. If the acceptance to be firm, so it should be unqualified acceptance, right? These types of the conditional acceptance for conditional acceptance, we can call them as the qualified acceptance, right? So while you are receiving the offer from the offer row, you will make a statement saying that this term has to be revised in this way, otherwise I won't sign, right? Without signing that particular acceptance, you will say. So that particular condition has to be revised by the offeror. In that case, that will be considered as a conditional acceptance. Second one is the express acceptance. Expressed in the sense you will express. Literally, you will express your acceptance in a letter, or let's say by signing, by sealing, by making your, placing your rubber stamp. So you will say that I've expressly, you will accept it. That is called expressed acceptance. And in some case, you are not going to accept it in a written way or written format, but of course you will conduct whatever you do. Like, let's say, it can be a business activity. You will conduct, you will make your acceptance through your conduct. Nothing is expressed, but by implying, you will make that acceptance. That is what you call as the acceptance by implied way. That is implied acceptance. Okay, so we'll move further. So there are so many characteristics of a valid acceptance. The acceptance to be valid, there are so many things to consider, right? Acceptance must be given only by the person to whom the offer is made. Now, let's say your father has been received an offer, but you cannot accept the offer. Why? It's addressed to your father. On behalf of your father, you cannot accept. But of course, when it comes to the legal consequences, let's say if your father has given his acceptance power or the attorney power to his legal officer, of course, they can, right? But in a case where the offer is made, now that is happening on behalf of, but when it comes to the acceptance of the offer, you may need so many documents to prove that that particular person has given the acceptance. It should be a disability or whatever, but it should be a proper way of getting that particular person's consent, or let's say the assent, to accept the offer by the legal personality even. Otherwise, the legal person would have been, given their signature and saying that accepted this offer, right? So you being the son of that particular person, even the father has received the offer, you cannot accept it, right? That is one way. The second one is acceptance must be absolute and unqualified. As I told you earlier, the acceptance must be unqualified. If you are giving a sort of a cross offer or a counter offer, if you are making some sort of revisions in those conditions, you cannot make any sort of acceptance, right? Okay, so that acceptance should be absolute, right? In the sense that you are going to accept that it as per the offer. Offer just came to you and you have accepted. That's it. Absolute, which is unqualified. Then third one is acceptance must be expressed in some reasonable manner. You can, even though you can do it in a way which is implied, but still the recommendation is to become a valid acceptance, you must express it, right? And the mental acceptance, the quiet assent, is not going to be work with the valid acceptance, right? Let's say if somebody was making an offer, you were in the silent mode. So where you cannot, they can't also presume that you made an acceptance by being silent. At the same time, quiet assent, or else the mental acceptance, that would be great, I should accept this. You're thinking, right? Your thoughts, it won't be a valid acceptance, right? So mental acceptance and the quiet assent will ineffectual invalid offers, valid acceptance. Acceptance must be communicated by the acceptor. The person who accepts it has to communicate that particular part to the acceptance to the offer row. And acceptance must be given within a reasonable time period. You can't take so many times, so many years, so many months to accept an offer. So it should be within the stipulated time period as it was in the offer. It has to be accepted during the reasonable or requested or stipulated time period. Acceptance must succeed the offer, right? It's clear. Reject rejected offers can be accepted only if renewed. Now, as an example, as I told you earlier, it can be counter offer, it could be cross offer. So it could be a sort of a refusal or revocation because of it. It could be a illegality or else suitability is not there. So because of that, you may have rejected it. So if it is a rejected offer, the offer can only be accepted by the offeree in a case of renewal. Let's say the terms and the conditions have been renewed and reviewed as well. Renewed and reviewed as well. So then you can think of signing or acceptance of that particular offer. Okay. So those are the characteristics a valid contract or valid acceptance should have. Right. What do you mean by a consideration? Now we are discussing about so many types of considerations now, right? But when it comes to the legal aspects of consideration, it's totally different, right? Well, I'm not going to give you much, these days it's quite impossible to listen for these types of lengthy lectures, right? I know, and also this is business law, right? But of course, what do you mean by a consideration? Consideration means a sum of money, a sum of value in currency, right? Whenever you are attaining to a contract, you cannot sign the contract without having a monetary value on it, right? So consideration is the price for which the promise of the other is bought. Now, as an example, if I say this particular property, or let's say it's a house, right? This house, the ownership of this house is transferred to this person at a cost of this, let's say 2 million, right? 2 million rupees. At a cost of 2 million rupees, I will assign, or let's say not the assigning, I will hand over the title of this, I will give the title of the house to this party at a cost of this. So that is my consideration. If the contract is to become a legal, valid and, legally valid document, it should be contain a consideration known as a monetary value, right? So when at the desire of the promisor, the promisee of any other persons has done or abstained from doing, C, or does or abstains from doing, or promises to do or to abstain from doing something such act or abstinence or promise is called as a consideration for the promise. See, right? It's that difficult, it's that complicated. But by the way, there are some essentials for the valid consideration. Now, I'm pretty sure that you have understood what the consideration is, but when it comes to the valid consideration, to become a valid consideration, there should be some essentials. Consideration must move at the desire of the promisor, right? It should be moved at the desire of the promisor as well. Then consideration may move from the promisee or any other person, right? As an example, when it comes to the consideration may move from the promisee by or any other person. Now, or any other person, sorry, promisee or any other person. Let's say that person has sold that particular property at a cost of 2 million, right? The 2 million is the agreed amount between the two parties known as offeror and offeree. Based on that only they've made a sort of a contract, like let's say it's basically a contract of sale, right? Sale of good, right? Sale of a property, right? It's made based on that. So it came from the promisor and the other party has received it, in the sense not in the monetary way, but that consideration is received by that particular person, right? Or the person who, whoever who named by the particular offeree. And the third one is a consideration may be past, present or future. It can be executory thing, or even nowadays, at the present, you can also consider, like, the consideration can be in the present as well, right? It can be already paid, or to be paid, or even now it pays, right? Now pays by a person, right? Consideration must be something of value. It should be not the barter, right? But when it comes to the contract of sales and things like that, we should have to consider about all these, contract of sales will discuss about the monetary values. But when it comes to the, the properties, the contract of properties and things like, uh, it's like there can be also barter values, but of course here in the contracts we are considering the numerical or the currency values. Exemption rules, because there are so many types of different acts to govern this barter system, the barter value considerations as well as the monetary value considerations, right? So be careful. And consideration must be something of value. Exemption rule on agreements are also there. Some of the exemption rules, right? So, made on account natural love and affections. Now, let's say you cannot consider a consideration on the agreements based on the natural love and affections, right? And which cannot be, which cannot be compensated for the past volunteer service. Pay a time-bound debt. Completed gift, cut. As well as there are some exemption rules on the agreements, right? The areas like the made on the account natural love and affection, compensate for the past voluntary services, pay a time-bound debt, completed gift, contract of agency, remission of promisee of performance of the promise, and contribution to the charity. You can also see the descriptive explanations for these all these exemption rules that I mentioned in this video. You can download a PDF from the following link. So yeah, so that those are the things that I've decided to discuss today. Of course, if you do have any concerns, please send me a mail, and also read the additional readings that I've given to you. Also, I will referring to you for case laws as well. So hope that you have enjoyed the business law session. Thank you very much.